colleagues.
Afternoon, Swala.
How are you?
No, you know, better than to ask questions like that because then I have to unmute and answer. I'm doing okay. Gosh, it's nice to be on leave, even though I'm working a little bit. And you? How are you doing?
I'm good, just overworked.
Well, that's all of us, so that's nothing unusual.
Yeah.
I'm just a bit worried about this COVID that's so hectic at the moment in Johannesburg. I hear people are literally lying in the hospital reception areas and things. So
Sure.
Dreadful.
Yeah, it's
Go
terrible.
anyway. Okay, I'm going to mute now again.
Oh, okay.
And then you want to chat? Sorry, you want to chat?
Yeah, I just wanted to mention that the unit drive document, they're quite urgent. I think, were you at the meeting earlier today?
No, I didn't because I'm on holiday. I apologize.
Oh, okay. So yes, maybe while you're on holiday, please attend to that because apparently the person who's supposed to assist us to upload on unit drive, she has 2 weeks with us. Thereafter, you'll have to do it yourself. So
okay, I've been, you know, my normal obstinate self. So I have the whole year's documents in certain folders, and I'm sending them the whole folder. But it's so stupid because it's actually already on Unidrive. So that's how it says, but this is crazy. But that's what I'm doing. That's what you want. I'm sending them all my documents because surely they also then want the, you know, the concession exams. They want the concession students exam papers, which we never handed in to anybody, which we always had. So I'm sending them everything.
That's a lot.
Exactly. Let them save it. It's nice.
Yeah. Okay. All right.
Okay. But thanks for warning me. I'll keep it in mind. Okay, yeah. I'm going to mute now.
All right. Okay, colleagues, I think we can get started now. I just realized that the ECP students only have a week, next week, I think, before the exam. So we're gonna have to make a plan. Maybe next week we might have 2 sessions to cover the remaining study units, but we'll see how that goes. I will let you know. And then the other thing for the ECP student again, I've sent out a notice about the Invigilator application. Please, guys, you have to familiarize yourself with that app. You are expected to use it in the exam. There is no way of getting out of it. You have to use it in the exam. So download it, familiarize yourself with it. I've also sent you the student guide, go through it. You cannot wait until the last minute to read the manual. Read it now. If there are any problems, let's deal with it now, not during the exam. And what else I wanted to tell you? I think that's about it for now. If you have any questions, please ask me. So I take it we are happy. We can, yes, Pokela.
Ma'am, I would like to know which act are we supposed to familiarize ourselves with?
Are you one of the ECP students? If so, then you ought to have received my email yesterday. So if you are not an ECP student, don't worry about it. When the time comes, I will tell you about it.
Okay, thank you, ma'am.
Yes, there is another hand. Unati, I think.
Yes, good afternoon, everyone. I just wanted to find out, I don't know if you had mentioned what format is the exam going to be in, please, if you don't mind sharing.
The exam is MCQ, multiple choice. You do it online.
Okay.
Yeah.
Thanks.
Okay. There is no more venue-based exams. It's online. All the exams are done online. Yes, Tidi.
Hi, ma'am. I'm an ECP student, so I'd like to know what act you are referring to. I'm writing quite soon.
Oh, okay. So all the ECP students, please, you need to keep an eye on your emails.
Yes.
Because there's going to be a lot of communication coming your way regarding the exam. So I did send out the email yesterday telling you about the Invigilator app. Remember, now you're doing the exam online, so we need to invigilate you because some of our colleagues, they like to copy and do unauthorized stuff. So the app is to keep an eye on you while you do your exam, if I may put it like that. Do you still have a question, CD? I see your hand is still up.
Hi, so it's not an open book exam. Is that why you need the invigilating app?
No, the exam is not, though you do the exam in the comfort of your home or wherever you are,
Yes.
It's not an open book.
Okay.
You can open the book. I will not know, Eunice, I will not know, but your conscience will know.
Okay,
Okay.
that's fine.
Yeah, one last question, CD, regarding the
No,
exam.
no, I'm fine. I'm just trying to figure out how to lower my hand.
Where you raised you pressed to raise your hand, I think that's where you will be able to lower your hand.
Okay.
Yeah, okay. So today any questions regarding the work that we did previously? Nothing. Okay, let's proceed. So today we're looking at study unit 4, servitude. What do you understand by servitude, colleagues? And I expect a lot of questions now from the ECP student since your exam is just around the corner. By now, I think you should be doing your revision. Anyone? Yes, Pogela. Just unmute yourself.
According to my knowledge, servitude basically servitude are entitlements to use someone else's property.
Okay. Anyone to add?
Ma'am?
Yes.
It's my understanding is that it's a limited real right in someone's either movable or immovable property.
Okay. Anyone to add? You are both correct. So while we still on that limited real right, what's the difference between a limited real right, a real right, and a personal right?
Ma'am, can I go again?
Yeah, sure.
Okay, so the personal right is actually linked to a person who has a limited real right, whereas the limited real right in land is not a personal right. It actually attaches to the land itself. So whereas in a personal right, when the person dies, for instance, that right falls away. Whereas if a limited real right is in the land, that survives the owner's death, for instance.
Okay, the real right. Then you want to try real right? Remember, this is a revision of what you did in property law. Okay, so I'm not sure what your name is, but on my screen it says project administrator. So
sorry, ma'am, I'm using my works PC, but it's Sandy.
Sandy. Oh, okay.
Thank you.
So Sandy mentioned that you said personal right is what? Something to do with limited real right, and then you mentioned limited real right. Okay, it was a bit mixed up there. So before I say something, do we have anyone to maybe add to what Sandy said? Okay, so personal right. Yes, Takanai, please go ahead.
I just wanted to add that real right is enforceable against almost everyone. It's a right that accrues to a person or to an entity, which right they can enforce against not only another individual but against others. That right is recognized by not only one person.
Okay, so other writers, they say that real right is an absolute right. Okay, Murray, you still want to say something? Please go ahead.
Sorry, I'm done.
Okay.
I'm sorry.
Okay. So they say real right, I mean, it's an absolute right because as the holder of that right, as the owner of the property that entitles you to that real right, you can do absolutely everything over your property, provided it is not against the law. However, then your limited real right comes in to limit that real right. That's where your servitude comes in to limit your real right. That's why your servitude is a limited real right, because it limits somebody else's real right. So if as a owner of a immovable property, for an example, I grant you a right of way, that right of way will limit my absolute right over my property. Right? I'm not sure if you follow me there. Whereas your personal servitude, it's a creditor's right. You can only enforce that personal right against a specific person. All right. So let's say Sandy borrows me her notarial practice study guide. That's her personal property. Between me and her, she can enforce that right, the personal right. Whereas if I take the book and give it to somebody else, I'm not sure if I'm using the correct example here, she will not be able to enforce the personal right against the third party. Whereas your real right, you can enforce it against the whole world. And your personal right is registrable in the deeds office in certain circumstances. All right. But your real right, to establish your real right, it has to be registered in the deeds office, and your limited real right has to be registered in the deeds office. Yes, Ms. Ramwell.
Thank you. I think I understand and I agree with you completely. I know that students always get this confused. So they confuse a personal servitude with a personal right.
Yes.
And so I just want to say this. So personal servitude is still a real right. Predial servitude is a real right and a personal servitude is a real right. And they both get registered in the deeds office. And they both give you real rights, as Ms. Nkuna explained. It's enforceable against the whole world, and that's why it's registered in the deeds office. But when you talk about a personal servitude, the personal part of it comes to do this, that it attaches to one person. Only one person is entitled to use that personal servitude.
Yeah.
Okay, so but they are both real rights, even though it's called a personal servitude. However, as Ms. Nkuna explained, the personal right is a right that is not registered in the deeds office. It's just a personal right. It's a contract between you and me and somebody else, and we can only enforce it amongst us who have made that agreement. It's not enforceable against third parties. I just thought I should emphasize that because I see it in my subject often. People get very confused with personal servitudes and personal rights. Not the same thing.
Yeah,
okay,
I also get that. That's why I specifically asked. Yeah, thank you for that. Okay, colleagues, are we clear? Do you require further explanation? Can we move on? Okay. So, as already mentioned, servitude is a limited real right over somebody else's property. And I've explained and given an example there. So, and as Ms. Ramwell has explained, personal servitude, it's in favor of a specific person, whereas your prior servitude is in favor of the land, not a specific person. However, as the owner of the land that is benefiting from the servitude, being your dominant servient tenement, you have entitlement to use the servitude. So let's say now Sandy has a farm where she grants a right of way to Tshidi. Sandy's farm will be the servient tenement, and Tsidi's farm will be the dominant tenement. Remember, you need two properties adjacent to each other to have your prior servitude. So Tsidi's farm is benefiting from Sandy's farm, and should and so Tsidi is entitled to the servitude by virtue of her being the owner of the farm. Let's say Tsidi now decides to sell her farm. The new owner, depending on for how long was the servitude registered for. Let's say now the servitude was registered for 100 years, for argument's sake. The new owner coming to take over Tsidi's farm will continue with that servitude, will be entitled to that servitude. The transfer of the farm from Tsidi to the new owner does not cancel the servitude. Whereas with your personal servitude, when Tsidi leaves, let's say it was a usufruct, and she abandons the usufruct or it's cancelled for whatever reason, or then the new person will not be able to use that usufruct because it's attached to Tsidi specifically. Only Tsidi can use the usufruct. Hopefully, I have not confused you, colleagues. So let's look at the page 45, characteristics of a servitude. So you cannot have a servitude over your own property. Let's say now, back to my example, Sandy had given or allowed servitude over or in favor of Tsidi's farm. Later on, Sandy buys, later on, Sandy buys Tsidi's farm. So meaning now Sandy owns her original farm together with Tsidi's farm, which had servitude over Sandy's property. So Sandy cannot enjoy that servitude that was granted in favor of Tsidi's farm, simply because you cannot have servitude over your land. All right. Remember, back to your real right and limited real right, you are now the owner. So you enjoy all the benefits of the land. Okay. And then a servitude cannot exist over another servitude. So now Tsidi, she has servitude over Sandy's land. Tsidi cannot go and grant servitude to Kulekani over that same servitude. You cannot do that. All right. And the holder of the servitude must exercise his or her right in the least prejudicial way. So Tsidi cannot exercise her servitude over Sandy's land in a way that is not favorable or conducive to Sandy, right? You have to take into account the needs or whatever for Sandy. Okay. Then a servitude cannot place a positive obligation on the owner of the savient land. So we cannot say, CD cannot say to Sandy that you have a duty to maintain this right of way. You cannot do that. Are you still with me, colleagues?
I'm still here.
Yeah, you are here, but the important
Please, can
people
you
are they here?
explain
Are they
number 4
following?
again?
Say that again.
Please, can you explain number 4 again? A servitude cannot place a positive obligation
On the owner of the savient land. So
Yeah.
remember I said in the example that I gave that Sandy's farm is the savient. It's a savient because it serves your land. Your farm is the dominant one. It's dominating Sandy's land, right? So you, by virtue of you having a servitude over the savient tenement, you cannot say to Sandy that I want you to maintain this driveway. Let's say it's a right of way. You cannot tell Sandy that it's your responsibility, it's your land to maintain this driveway. You are the one using the land, remember? Yeah.
All right. Thank you.
Okay. Okay, so the right of the holder of the servitude is absolute and thus enforceable against the whole world. So that we have already explained. Servitude must be enforceable by someone. The holder acquires a limited real right in respect of the owner's property. So that is also self-explanatory. Okay, so yes, so those are basically the characteristics of servitude, regardless of whether it's a personal servitude or a prioral servitude. We'll later on look at personal characteristics of personal servitude and prioral servitude. So now on page 46, there's a doctrine of notice. I wonder if you've gone through that example. Basically, you have where, let's say, yes, Pogela.
Ma'am, this is a personal question. I just want to make sure that you are good. Are you comfortable?
Why do you think like that?
You do not normally explain the things in this way, and it's kind of like you are suffocating the way you are explaining.
No, I'm good.
Things.
Am I going too fast?
No, ma'am. Thank you.
Okay. No, I'm good. Thank you. Okay. So if I'm going too fast, you must tell me. If I'm going too slow, you must tell me. Okay. So, yes, the doctrine of notice. It does happen. Let's say now back to our example. Sandy and Sidi agreed on a servitude. So the servitude is not registered in the deeds office. It's an agreement between the two of them, known by the two of them. Later on, CD sells her property. If the third party, let's say it's Opa buying the property, if Opa is aware that CD's farm is enjoying servitude over Sandy's land, then he will be able to claim that servitude. Right? If Opa was not aware of the existence of that unregistered servitude, he cannot claim that servitude from Sandy. But if the servitude was registered in the deeds office, then Opa can claim that servitude. So now to take it a bit further, let's say now Opa was not aware of the existence of that servitude. He purchases TD's land. Later on, Opa sells that same farm to Thabang. Thabang, who was aware of the existence of that unregistered servitude between Tshidi and Sandy. What do you think, or do you think Thabang will be able to claim enjoyment of that servitude?
He would, ma'am, because he has knowledge of the existence of the servitude.
Yes. Murray?
Of course, he would.
Okay. Opa?
I think, ma'am, he would, because remember the servitude is registered in the deeds registry. So upon the purchasing of the land and upon the linking of deeds, that's where it will become evident that there's a servitude which exists between this person and that. So that's how my understanding comes into play.
Okay, so we could hardly hear you, Opa. There was a break there. I'm not sure if it's your network or if it's on my side. However, what I gathered from what you said is that the servitude is registered. My facts were that the servitude is not registered. So remember, previously I mentioned that whatever is registered in the deeds office is public knowledge. So no one can claim ignorance or whatever. It's public information. Everyone is free to access that information. So in this fact, the servitude is not registered, but Thabang has knowledge of that servitude. So my question was, will Thabang be able to claim that servitude from Sandy? Do you want to try that again? Okay, so yeah, Sandy and Murray have answered that question. So let's proceed, colleagues. And then the characteristics of prioral servitude. Prioral servitude, remember, there has to be two lands adjacent to each other. And the servitude holder enjoys the benefit of the entitlement of the servitude in his or her capacity as the owner of the land. If that person loses his or her ownership, then the person loses the entitlement or the enjoyment of that servitude. Okay. And then it can be granted only in respect of immovable property that I've explained. Two pieces of land, we have the dominant and the servient tenement. I've explained that. And it's always created in favor of a person only in his or her capacity as the owner of the dominant tenement. Remember now when you register your servitude, prioral servitude, the dominant tenement commercial value appreciates, whereas your servient tenement commercial value depreciates. I wonder if we have anyone who would like to comment as to why that is the case. Why the appreciation and the depreciation of the value in the two properties. Yes,
I'll try, ma'am.
Yes.
So if you take the dominant tenement and they have limited real rights in someone else's property, that enhances the value of their dominant tenement. However, with the servient tenement, the rights are being limited, restricted, and therefore that takes away, I want to say value, but I'm not entirely sure of my thinking here, but that takes away from the complete right of the servient, the owner has in his servient tenement.
Okay, Murray? Moray, unmute yourself.
Okay. Yeah, what happens is the servient tenement suffers from additional inconvenience and or interference and interruption by way of having granted the servitude. For example, if there is a road that is going to pass through the servient tenement property, things like noise, dust, and the general lack of privacy will come into play. Whereas with the dominant tenement, they then maybe such road reduces the distance that they have to travel or costly road construction expenses which they were going to meet had they sought to construct a road that wasn't going through this property in such a way so the economic or financial value of the dominant tenement is enhanced.
Anyone to add? Okay, so yes, colleagues, the dominant tenement has the added benefit or entitlement that it's enjoying from the servient tenement. So that's an advantage to the dominant tenement. Whereas your servient tenement, it's burdened by something else, your right of way or right of grazing or whatever, right? So yes, okay, so let's proceed. So your prioral servitude can be granted, can be perpetual in nature, or it can be for a limited period of time. And that's why earlier I said it's attached to the land and not the owner. Remember, the owner as a natural person, you can die anytime. So if it's attached to the person, when you die, then it means it's the end of your prioral servitude, like your personal servitude. Whereas your prioral servitude is not attached to the person, but to the land. So that's why it can be perpetual in nature, or as per parties agreement, it can be for a limited period of time. And it is inseparably attached to the land and can be transferred only with the land. Right. And you cannot divide your servitude. And I've mentioned it has the two pieces of land has to be adjacent to each other. So you cannot have a servitude over two pieces of land where one piece of land is situated in Pretoria, the other piece of land is situated in Durban. The property has to be they have to be neighbors next to each other. And it must serve for the benefit of the dominant tenement. And I've mentioned it enhances the value and the use of the dominant tenement. And there is no prerequisite for the contents of the prioral servitude, and it can therefore be framed in various ways. Okay, so questions, colleagues, or comments before we proceed to personal servitude? Yes.
I'm good. I think we can move.
Okay, thank you. So personal servitude, as previously indicated, it attaches to the person. It's for the benefit of a specific person and not everyone. And then the characteristics thereof, it can be acquired over one or more movable or immovable properties belonging to somebody else, right? And it can be granted in favor of a specific persons or persons in a inseparably attached, and is inseparably attached to the person of the beneficiary. We've already explained that you cannot grant a personal, or you cannot be a holder of a personal servitude and want to transfer it to somebody else. However, you can transfer the entitlements. We'll unpack that just now. Okay, we mentioned it cannot be transferred. So the paragraph under item 3, starting with, we must distinguish. Can we look at that, please? That's where I'm talking about. We must distinguish between the non-transferability of a personal servitude and the transferability of the entitlement of a personal servitude. The holder of a personal servitude can let, sell, or even encumber with a mortgage his or her entitlement of use and enjoyment. However, if the personal servitude terminates, the entitlement granted in terms of personal servitude lapses automatically. Okay. So basically, yeah, as a holder of a personal servitude, you cannot transfer your servitude, but the entitlements, your enjoyment right, you can transfer. Let's say it's usufruct. You have a right to stay in a property, or let's say a right to occupy a back room in somebody else's yard, land, right? So you have the entitlement, or you have the the right to enjoy the property that your servitude encompasses, right? So as the holder of that personal servitude, you have the right to, you can lease out, you can rent out that room, for an example, and enjoy the rental, all right? You can, if it's possible, let's say maybe it's over the whole property, you can mortgage that property. You can register a mortgage bond over it. But just remember, when your servitude comes to an end, whatever entitlement that you've given to third parties automatically ends. So if you're gonna give entitlements to third parties, it has to be limited within the period with which your servitude allows. And you can sell your entitlements, of course. Yeah. So let's say you have a personal servitude over a tractor, a farmer's tractor, for example. Remember, the tractor is a movable property, and you have a personal servitude over that tractor. Can you mortgage that tractor? And what kind of mortgage will you register over that property? Where's your critical thinking skills? Go back to your notarial bonds. We said notarial bond is registrable over movable property. Yes. So now, as the holder of the usufruct, you have the right to enjoy this tractor. And we are told that you can transfer your entitlement, you can mortgage your entitlement. So you are entitled to enjoy this tractor. Can you register a bond over those entitlements? Well, that's something for you. Yes, Marie.
Yes, you should be able, if it is a usufruct, because the entitlements of such provide that you can encumber the item in question, whether it is a movable or an immovable, of which through an NGCB, that is the Notarial General Covering Bond or specific notarial bonds, you can encumber you can register a bond over the trust, as long as it is within the period of the servitude.
Okay, what do others think? Do you agree with Murray? Yes, no? Okay, I think maybe something for you guys to think about. Yes, think about it. Okay, so let's proceed. Yes, the last one, you cannot register a personal servitude in perpetuity simply because, remember, it's attached to a specific person and there is no human being who lives forever and ever. At some stage, we leave the world. So that's why it cannot be registered in perpetuity, unlike your prioral servitude. Right. Okay. So, yes, Murray.
I want to know if my answer, if my thinking was correct. Otherwise, I'll then maybe keep in mind a wrong position.
No, you were correct. Okay, so we proceed. So I think the types of personal servitude, those are straightforward, colleagues. You can read through them. Remember, I mentioned that we're only looking at the problematic section, so we're not going through everything, except if there's something specific that you want me to look at. Okay. And then let's go to page 50. All right. So the creation of prioral and personal servitude. All right. So there's going to be an agreement between Sandy and Siri that they want to create a servitude in favor of Siri's land. So this agreement, for it to be enforceable against the whole world, it has to be registered in the deeds office. Before it's registered, it's only a personal right that CD has against Sandy's land to claim the use of her land as per their agreement. All right. So now it's going to be registered. It becomes your limited real right. So how is it created? So it has to be registered in the deeds office through your notarial deed of notarial servitude. Yes. And it can also by means of reservation in a power of attorney to pass transfer of land, which is then registered in the deeds office. So the difference between the two, by the two meaning the reservation in the power of attorney or your notarial deed of servitude, is that your notarial deed of servitude, it costs money. That's a separate deed that you will have to lodge in the deeds office, which you will require the service of a notary to execute that servitude and have the parties appear before the notary and. However, if you're going to go through, use the reservation in the power of attorney, it will not cost any extra money on your client. However, not everyone can use that reservation in a power of attorney. So paragraph 4.5.2, it gives instances where you can reserve your servitude in a power of attorney. Let's look at that. If it's in favor of the transferor, right? So let's say now Sandy sells her farm to Jabulile, right? And the agreement is that Sandy will have a right of way over her property, which soon will belong to Jabulile. Right? So Sandy will be the transferor. So in that case, we can reserve the servitude in the power of attorney. And the next one will be in favor of the transferor and his or her spouse or the surviving spouse if they are married in community of property. Remember, where parties are married in community of property, there's one estate. So that's why in favor of the transferor and his or her spouse or the surviving spouse. So let's say now Sandy sells the property to Jabulile, subject to a right of way being given in favor of Sandy and her partner whom are married in community of property. Then that servitude can be created by means of reservation in your power of attorney. So let's say now Sandy's partner, God forbid, is deceased. So as the surviving spouse, and they were married in community of property, so as the surviving spouse, their right of way can be reserved in the power of attorney in favor of Sandy. Right. And then the last one, in favor of the surviving spouse, if transfer is passed or given from the joint estate of spouse who were married in community of property. So that I've explained. Happy? Are you still there, guys? Yes, Murray.
Yeah, I think we are quite, but it's a bit confusing. If the right of way to remain existent in favor of Sandy's spouse, if they are married in community of property, but if it is a predial servitude, does it really matter that the one spouse's demise is passed on, it being a predial in that it's registered over one property by another, never mind by the owners? Does the predial servitude terminate?
So can I just interrupt you there? Can I just interrupt you? Remember, right of way, it's a form of prior servitude.
Yes, ma'am.
Yes. Yeah, you can go ahead.
So, if your property where you stay as we speak is registered in your personal name and you are married out of community of property, and you then go on to negotiate a servitude over your neighbors with your neighbor, and you become the dominant tenant. If you pass on your heirs through your property, which they will inherit, do they then lose the rights of servitude, or they remain? That's my question in short.
Okay. Can somebody please assist us here? Please try, colleagues. Okay. So remember we said that your servitude, prior servitude, right of way, grazing, and whatever else, there's a lot of them, they are in favor of the land, not the person, right? So if somebody dies, the servitude does not die with the person, if I may use that word. It remains, all right? So in your question, when somebody passes on, that right of way will remain. It will not cease simply because the owner of the land is no more. All right. So now, where the parties are married in out of community of property, I mean, they cannot use this they cannot create their servitude using the means as stated in paragraph 4.5.2, simply because they are married out of community of property, and the reservation in the power of attorney covers only if you are married in community of property. Ray, are you answered? Yes, ma'am.
See, 4.5.2, dot number 2, that point there. I don't seem to connect with the relevance of the need to mention in favor of the transferor and his or her spouse or the surviving spouse if they are married in community of property. Because if it is pridal, it is on the property. So it's regardless of whether there is a spouse or surviving spouse or etc. This is my thing. It's getting me a bit confused in that it was needless to mention in community of property or with their spouse or surviving spouse, because it is upon the land. So whether it is in community of property or not, whether it is together with the spouse or not, I thought that all that fell away or became irrelevant. That's where my confusion was emanating from.
Oh, okay. Before I give, I think Ms. Ramos' hand was up. Can I maybe just quickly mention that? Remember, you're married in out of community of property. I mean, there is 2 separate estates. So the husband has his own estate. The wife has her own estate. So therefore, we cannot reserve the servitude in the power of attorney because, let's say it's the wife who passed away. We cannot reserve in favor of the wife in the power of attorney because she was never an owner of that property. I'm not sure if you follow that. So that's why we're going to use your notarial deed of servitude if we're going to create the servitude in favor of her who was married out of community of property. Remember, the title deed only has the husband's name because they were married out of community of property. So now, even if they were, both of them were owning that property jointly, but the mere fact that they were married out of community of property, the wife owned her share. Now she needs to get servitude over the husband's share, which did not form part of her estate while he was still alive. I'm not sure if my explanation makes sense there. Ms. Ramuel, you wanted to say something?
Yeah, I actually took my hand down because I thought, yeah. I wanted to ask exactly that question. So, all right, in a farm, you can only register it in the name of one spouse. You can only register a farm in the name of one person. So there your example holds true. And I can understand what you're saying there, in that the sense that, let's say it's registered in the name of the husband and he's married in community of property, then the wife is owner, although she doesn't appear in the title deed. And then if he were to sell the property and reserve for himself and his wife in community of property usufruct for the rest of their lives, that would be fine. But if we're not talking about a farm, if we're talking about something else, like just a house in the suburbs, and they married in community of property, the same thing would apply. But if they were married out of community of property and it was registered in the husband and the wife's names, one half share for the husband, one half share for the wife, out of community of property, and they then transferred the house to their daughter with the usufruct in favor of themselves, I think you could do that. I think you could reserve it because they both transfer raws, and you're entitled to reserve a right in favor of the transfer raw. But I'm not sure. I'm asking the question.
You're asking me the question.
Yes, no, because yes, because I've never done anything like this, but that's what my logic tells me.
Okay.
But I think I'm confusing things because I'm going into this now much more deeply than what is needed for what we're studying here. But it's, I'm just trying to explain that the logic there of the in community and the out of community of property. Where you're in community of property, you're anyway an owner. So you are part of the transfer raw, even though your name might not be in the deed. But when you're out of community of property, it would matter whether you are a transfer raw, whether the property is registered in the spouse's name as well, I think.
Okay. So,
okay.
Thank you for that. I'm not sure how to answer that question, but when you look at the last study unit 8, selected legislation, we will talk about more the farms, yes. So basically, I think it's section, the subdivision of Agricultural Land Act. We'll talk about that when we get to study unit 8, yes. So with farmland, basically what happens, yes, as Ms. Ramuel has already explained, that if you can only register a farm in the name of one person, not multiple owners. Yes, that's correct. However, if you are married in community of property, remember we have one joint estate. Therefore, it's the joint estate that is acquiring that farmland. So that's why in the title deed you'll find husband and wife married in community of property. But if it was out of community of property, you'll find only the husband's name, who is the owner of the property and not the wife. All right. So you will not find the husband, let's say they are married out of community of property, you will not find them being the joint owner of the farmland. You will not find husband married out of community of property and the wife married out of community of property, but there has to be only one owner of the farmland. So we will unpack that when we get to that chapter. I'll explain more. So yes, back to what we were discussing here. I think I'm also getting a little bit confused, but I know what I want to say. That, yes, Ms. Ramuel.
Oh my goodness, sorry, I just forgot to mute. I'm sorry.
Okay. So yes, so let's say back to our example where we're talking about the farmland. I've explained that farmland, and as Ms. Ramal has already explained, you cannot have farmland owned by multiple owners. But if it's a joint estate, married in community of property, yes, that's fine, it can be done. So in that case, they are married in community of property, you can reserve by means of power of attorney. But if they were married out of community of property, your title deed will tell us that it's only Murray who is the owner of that farmland. And now Murray wants to reserve a servitude in favor of his wife, right? So you cannot do that by means of your power of attorney. You will have to use your notarial deed of servitude, simply because this wife was never a joint owner of that property. She is not the owner of the property. So you transferring, or you giving the rights to entirely a new party, if I may put it like that. I hope I did not confuse you with this long explanation.
Ma'am, can I just ask for a clarification? So
yes.
If people are married in community of property,
yeah,
the personal servitude attaches to both of them.
Then that will be the joint estate.
That's the joint estate. So
Yes.
it attaches to both of them by virtue of the fact that they're married in community of property. I think.
Yes. Okay. Any other comment, question? Okay. Let's proceed. I think the rest there, it's self-explanatory. I'll just mention in page 51 that when you're registering a servitude, in some instances, you will need to have a diagram. But we'll not go into detail on that here. Okay, and then page 52, termination of your servitude. You can cancel by agreement or unilateral waiver by the holder of the right, or when it becomes impossible to exercise the servitude, or through lapse of time or by measure. Mostly, students do not understand the principle of measure. Back to our earlier example, where Sandy and CD, no, I think it's Sandy bought Jabulile's property where there was a servitude in favor of Sandy. And I said that now Sandy cannot continue to enjoy that servitude because she is now the owner of the property. You cannot have servitude over your land. So that servitude automatically lapses by the principle of measure. All right. Because now the owner or the holder of the servitude has become the owner of the servient tenement. So also by means of prescription, if you have a servitude and you don't exercise it for a number of time, I think 30 years, then it will automatically lapse. And by legislation, for example, in case of expropriation. So do we have questions, colleagues? Yes, no? Okay, I think we are good. Then there is also lapsing of servitude. When the servitude has served or run its course, it will lapse. In some instances, we just leave it as it is. However, in some instances, you'll have to go to the deeds office in terms of section 68(1) and note the lapsing of the servitude. Right. And I think that's about it for servitude. If you want us to go through the questions, please indicate which question you would like us to look at. Are we happy? No questions? I think, again, the problem of not being prepared for the discussion is a problem. Anyway, I think we'll leave it here for today. Then I will schedule another meeting for next week, Tuesday. As I indicated earlier, that we might have to have 2 sessions next week for us to be able to cover the rest of the work before the ECP students write their exams. So I think we are done for today. Thank you.
Thank you, ma'am.
You're welcome.
Thanks, ma'am.
It's a pleasure.
Thank you.
You're welcome.
Thank you, ma'am.